Why did judges make a rule protecting judges from discipline? If judges were everything they claimed to be, there would not be a need for such rule, right? Colorado adopted a constitutional amendment in 1966 providing for the discipline of judges. The amendment states that a judge may be disciplined for any violation of the Code of Judicial Conduct. Unfortunately, the amendment gave the Supreme Court the power to make procedural rules regarding the discipline of judges. There is a conflict of interest in allowing judges to make rules regarding the discipline of judges. In the 1980s, the Supreme Court acted on that conflict of interest and adopted a rule requiring the executive director of the Discipline Commission to dismiss any complaint based on an appealable order. The result? There has not been a published case of judicial discipline in Colorado since 1986. Over the last 10 years, the executive director of the Discipline Commission has dismissed 89.5% of complaints based on the unconstitutional rule without even looking at the merits of the complaints. Has someone challenged the fact that the Discipline Commission was not disciplining judges? Sure they did. The court's response? A published case ruling that no one can challenge what the commission does or does not do. Comparing the discipline of judges with the discipline of attorneys is somewhat revealing. Attorneys are being disciplined. Last year alone, there were 18 disbarments, 25 probations, 46 suspensions, and 73 diversion agreements. That's in 1 year. Of course, attorneys do not get to draft their own rules regarding discipline. An equivalent rule for attorneys would be to require attorney regulation to dismiss any complaint related to the representation of a client. Voila! Attorneys would look perfect to the world, when in reality the misconduct is simply being covered up. Let's look at the big picture. Here's the American form of democracy, 3 equal branches of government. Here's Colorado's current form of government. 2 branches are subject to term limits, contested elections, ethical rules, and the Independent Ethics Commission. The judicial branch is not subject to any of these. How bad is it? If you lie in court, it's perjury. If a lawyer lies in court, he's disbarred. If a judge lies in court, high five. This affects all of us. Laws have become mere suggestions. But we can fix this. We simply have to edit amendments currently in the Constitution. The conflict of interest in judicial discipline must be removed. We can do that by transferring the power to discipline judges to the Independent Ethics Commission, the commission that already is responsible for disciplining executive and legislative branch officials. The burden of proof in all such proceedings would be the same: equality amongst our 3 branches of government. Makes sense, doesn't it? We'd have accountability and also transparency because the proceedings would become public after a finding of probable cause. This is exactly what the Honest Judge Amendment proposes. But how did we get here? How has the judicial branch been able to systematically and unconstitutionally cover up judicial misconduct for almost 30 years without being publicly exposed? We got here because people don't pay enough attention to uncontested judicial retention elections. There is not a contest between individuals that brings a candidate's flaws to light. Nationwide, the mean average of yes votes in judicial retention elections has not fallen below 75% over the last decade. The lowest mean yearly average of yes votes was in 1990, when it was 69%. How many judges have lost retention elections? Less than 1%. Between 1964 and 2006, there were 6,306 judicial retention elections. In only 56 of those elections were judges not retained. That's a rate of 0.8%. It's next to impossible to move voters from the average 75% rate of yes votes to retain judges. In most elections, we're voting on a certain policy or for a politician to pursue a particular platform. In judicial retention elections, we're looking for the exact opposite. We're looking for judges who will be fair and impartial. Why then are we using the same measurement to determine these elections? In 1971, Illinois raised its required amount of yes votes to 60%. Critics say it isn't high enough, but Illinois is on the right track. We should use a different measurement when evaluating judges. Research shows that changing the standard to a 2/3 majority, or 66 2/3%, will not result in a lot of judges being unnecessarily removed from the bench. Indeed, again, the current average amount of yes votes for a judge is 75%. Changing the retention level to a 2/3 majority will increase accountability in the judiciary without unnecessarily rocking the boat. We are more likely to have a fair and impartial judge if 2/3 of the people agree that the judge will be fair and impartial. And that's exactly what the 2/3 majority amendment proposes. Shouldn't we have that much confidence in the judiciary? After all, a 50% score on a test is a failing grade. Colorado's current simple majority standard has led to almost 30 years of self-dealing by the judicial branch. Enough. The purpose of discipline and accountability is to protect the public. We have not been sufficiently protected for a long time. It's time for a change. My name is Chris Forsyth. I'm an attorney and I've practiced for 20 years. As an attorney, I'm sworn to uphold the Constitution. The Constitution states that a judge may be disciplined for any violation of the Code of Judicial Conduct. As an attorney, I'm also sworn to uphold the rules of professional conduct. Those rules prohibit assisting judicial misconduct. And as a member of the bar, it is my duty to improve the justice system. I'm upholding all of these duties by pursuing these initiatives. But some unusual people are getting in the way. A member of the bar is challenging the title for the Honest Judge Amendment. A law firm was hired to represent her. The managing partner of that firm is a member of the State Commission on Judicial Performance, which is responsible for recommending whether Court of Appeals and Supreme Court justices should be retained. A member of the State Judicial Performance Commission wants to keep judicial misconduct covered up. She is betraying the public trust and acting in direct contradiction to her duties on the commission. Who is paying her? The Executive Council of the Bar Association, which, if you remember, has the duty to improve the justice system. But it all makes one thing quite clear. Colorado is completely upside down from where it's supposed to be. The Honest Judge Amendment and the 2/3 Majority Amendment are well-drafted, common-sense solutions that bring accountability and transparency to our judicial branch, which will result in greater public confidence in the judicial system. There are 337 judges who would be covered by these amendments. That's in comparison to the more than 5 million people in Colorado which they rule over. Judges should be someone special. These amendments would help ensure that judges are someone special. We need a lot of signatures, 86,105 to be exact, of registered voters to get on the ballot. So we need your help and support to get this done. Please contact Clean Up the Courts today about how you can help get these initiatives, number 79 and 94, on the ballot. Together, we can improve the justice system for generations to come.